We're going to call the governing board meeting for Liberty Elementary School District to order today, Wednesday, May 7th at 5:30 p.m. here at the Jerry Roby District Facility. 4 board members are present. It's Board Member Zimmerman, Vice President Kenyon, Board Member Strencioni, myself, Michael Todd. Our first item on the agenda will be item 1.2, the Pledge of Allegiance. And let's see, I think, Mr. Strencioni, it's your turn to lead.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Got a little seat malfunction. Okay, good thing he's tall. He can still see over. Okay, we'll move to item 1.3, approval of the special meeting agenda. Take a motion in a second.
Mr. President, I motion that we approve the agenda consistent with board policy BEDB and temporarily suspend governing board policy with which this agenda may be inconsistent.
Okay, do I have a second?
Second.
Okay, I have a motion and a second to approve item 1.3, the special meeting agenda. If there's no discussion, I'll go for the vote. Board Member Zimmerman.
Aye.
Vice President Kenyon.
Aye.
Board Member Strencioni.
Aye.
And he's got a new chair. I'm also an aye. We will show that approved 4 yes, 0 no. Thank you, Ms. Camerata.
Thank you.
Next on our agenda is item 2.1, discussion, consideration, and approval of the Trust Policy Chapter 1. This will be the third read to be effective on July 1st, 2025. Dr. Mahorn, anything you'd like to add?
Nope, it technically has my name on it, but I'm going to immediately hand it over to Ms. Castellanos.
All right, Ms. Castellanos.
All right. Thank you, Dr. Mahorn. Well, governing board members, it is a pleasure to be here again today. We are here to discuss any review or any edits that were made to Chapter 1, and then we will be taking a vote if you all are ready to vote on that. So looking or reviewing Chapter 1, I'd like to open that up for any discussions if you have them.
The only thing I would like to discuss is about when we pay performance pay.
Can you?
That's
just,
in
Ms. Zimmerman,
Chapter
really
2.
quick? Yeah, if you can give us a page number.
Yeah,
so we can flip to it
I'm
really quick.
attempting to get to it. I apologize.
So that will be our next agenda item.
Oh, I so apologize.
No worries. I just want to, it's been a lot of trust policy over
Yeah.
the last month. So
Okay, anything else for Chapter 1? All right, hearing none, we can take a motion in a second.
Mr. President, I motion that we approve the Trust Policy Chapter 1, third read effective July 1st, 2025.
Second.
Okay. I have a motion, a second to approve the trust Chapter 1 policies to be effective July 1st, 2025. There's no discussion. We'll move to a vote. Ms. Zimmerman.
Aye.
Vice President Kenyon.
Aye.
Board Member Strencioni.
Aye.
I'm also an aye. Will show that approved 4 yes, 0 no. Also for the record, Ms. Schmidt is unable to join us. I apologize for not announcing that sooner, but Ms. Schmidt was unable to join us today, so we'll show her absent from the meeting. I apologize for not doing that housekeeping at the beginning. Okay, we'll now move to our next agenda item, which is item 2.2, which is discussion, consideration, and approval of the Trust Policy Chapter 2, third read to be effective July 1st, 2025. And Ms. Zimmerman, I think you've got one queued up.
Yeah, so it's page 2.
yes.
And, I don't want to repeat everything I've already said. So I stand by the fact that as it's the red line, I'm comfortable with it being, I think it should be June 30th. I don't think there's 31 days in June. But I'm comfortable with it between June and June 30th, or if the board would like to open it up until July, I would just personally like to see it after June 1st is what I'm looking for.
So the current red line edit right now is June 1st to June. We will change the 31st. So thank you for catching that, but June 30th.
Okay, so members, if the motion goes without any changes, that would be approved to do it as the June 1st to June 30th.
Mm-hmm.
Is there anything else in Chapter 2? All right, hearing none, we can take a motion, and I'll take a second as well.
Motion to approve the trust policy, chapter 2, third read, effective July 1st, 2025, with the change noted.
Okay, do I have a second?
Second.
Okay, I have the motion and the second to approve Chapter 2 of the trust policies to be adopted and into effect on July 1st, 2025. If there's no discussion, we'll take the vote. Board Member Zimmerman,
Aye.
Vice President Kenyon,
Aye.
Board Member Strencioni.
Aye.
I'm also an aye. We'll show that approved 4 yes, 0 no. All right, moving right along, we'll go to item number 2.3, discussion consideration of the trust policy, Chapter 3, second read. This too would be, if adopted, would be effective on July 1st, 2025. Members, I know this one's been a little fresher for you. We did 1 and 2 a few times, so we can take this one a little more in depth if need be, but I think the red lines are in there, so we can hopefully move through it relatively quickly and efficiently. Ms. Zimmerman, do you have anything you'd like to comment on this one?
Yeah, so do you want me to go through all of mine at this time?
I think everybody's had the chance to review it, but if you want to just go to the changes, that would be great, and
Yeah.
maybe just try to move through it as
Okay.
efficiently as possible.
So page 34.
Yes.
Okay, I was just giving people time to chance to look. So it's talking about a contractor or a vendor not being able to obtain a clearance card, and it's only the superintendent can waive it if they're certain that they're not going to interact with children. The only thing I'd like to add is if we could notify the principal so that they're just aware, even though we don't believe that they're going to have a reasonable access to children, like it's still their principal's responsibility, to keep the children of their campus safe. So if this waiver is granted, I would just like us to see if we could notify the principal.
Okay.
Anybody object to that? All right, Ms. Zimmerman, go with your next one, please.
Okay. Page 41. Again, these are all things that were redlined to be, as part of it. I'm not adding anything. My question still is, as it was when we did the first read, is there doesn't seem to be policy around, this is about the facilities, is how is there always a district employee on campus? Who's opening? Do people that rent the facilities have the ability to have keys? Who decides if the rental is approved? None of that is in policy. That was previously in policy. So I'm just wondering, can that be added? Just so that we're clear and we know how we're handling, especially to me, the keys, how are we ensuring that our facilities are safe, essentially, and protecting our assets.
Is that previously, and these are all starting to run together, was that in the facility use agreement where we had our fees and all that information, or was it originally in the policy?
It was originally in policy KF-EA and KFRB of the ASBA policies.
So I guess, Mr. Dangerfield, I'd ask you, should we put this, include it in policy, or should it fall under more operations of the facility use agreement handbook?
Thank you, Mr. Todd. You guys hear me?
Yes.
Okay. So what Ms. Zimmerman is referring to can easily put into the application form of the policy. The trust has informed us that they do have a possible application form as a template for the rental of school facilities, and we can build into that application form some of those specific issues. And that can be part of the policy manual under procedure.
Okay, Ms. Zimmerman, does that suffice for an answer for you?
I just am concerned about the key part. Are we giving keys to people who rent our facilities, and how do we? I understand the procedure of how it's approved. I can understand that would be there. To be honest, there's a lot of procedure in the trust policies that were not in ASBA. So I feel like we're picking and choosing what procedures we're putting in these policies, but I am concerned about do we have a district employee on campus to ensure that we're protecting our assets when a facility is being used?
President Todd, can I speak, please?
You may, I was going to ask you, I know you've handled these for
And board
many years.
members, yes. In the facility use paperwork, there is, where the fees are located on the bottom of that, it does say keys, access, and who's going to open and who's going to close and who's going to stay on site. We can definitely add to that, but that is there already. And usually facility use is kept at the school site with them, figuring out who's staying, who's opening, who's giving keys. So
My question is, do we give keys to people that are not employees at this time?
I could only speak to when I was at Estrella Mountain, and the answer would be no.
Okay, but it's not a general policy at this time. It's up to the school administrator whether to give keys.
Or the office manager, as I was one.
Okay.
So each school site, like I said,
I think that leaves a lot of room for interpretation here. And I personally find it concerning. So that's my personal opinion.
If I can,
Yeah.
if I can interrupt, I think
Oh, sorry.
this may, no, that's okay. I think this may be one that we need to ask Bob to make sure, because I would as well be uncomfortable giving someone that's not an employee a key. I don't think we do, but I can't say 100%, so I wouldn't be comfortable saying 100% for sure that we don't.
and then President Todd and fellow board members, along with that though, then what about the vendors that come on campus? They are supplied keys if they're going to remain after hours.
Give me an
And they're
example,
not
just
employees,
give me an example of who you're talking, like, just so I can wrap my head.
like the security system.
But they're contracted.
They are contracted, but they're giving keys if they stay after hours. They're not employees.
Right. And I think it could put a burden on our employees, right? If we are renting facilities and we're asking them to always come. I guess I just want clarification so that we're, being fair to every, you know what I mean? I just think that the fact that we're not sure how schools are doing it, we're not doing it consistently.
Can I ask a few questions?
Yeah.
Okay. So is what you're asking for is to have a policy so that it is uniform and that we know across the district what happens with keys? Because this is only talking about the reasonable fees charged for school facilities, right? So we're not talking about vendors right now. We're just talking about
Correct.
space rental.
Yes.
So if I was to take the sections out of KFEA and KFRB, that specifically related to keys and safety concerns and put them in here, would that help? Or is that what you're looking for? Is that what you're asking?
Yes.
Okay. So I will go ahead and take this back and add those sections in, and then bring it back for review for this specific policy.
Okay. And I think if we're going to take those as a whole and we get to the point where we can adopt this tonight, we can adopt it with adding that language in, and then you don't have to bring it back for a third read. I don't know where we'll end up, but I would be comfortable saying we'll just, basically you're going to cut and paste.
I cannot cut
You
and
can't
paste
but
anything from
yeah.
ASBA.
You'll finish the language. You'll fix the language as such that it matches this, right? Okay.
Yeah.
Sure. Okay.
Okay. On page 43, this is talking about political signs on school property at any time, including election day at school sites that are used as polling places. And my question is, this was obviously a big concern at the last election. And so my question to Clyde at this read was, on election day, when we are a polling site, signs can be outside of the 70. I don't think that this is legal right here, saying you can't put signs outside of the 75-foot line because the police report says otherwise. So I'd like some legal clarification here.
Yes, if I could respond to this, Ms. Zimmerman, the the language that's in here is actually from the statute and the Attorney General's guidelines. In normal polling places, the 75-foot limit applies. But on school property, the school is not supposed to have political activity on school property like that. So it would be appropriate, though it will be hard to administer, it would be appropriate to have it off of the school property and outside the boundaries, out to the side of the sidewalk or whatever.
Okay, but
Beyond
the
this-
sidewalk is not school property, correct?
Generally, it's right after the sidewalk. The buffer zone between the sidewalk and the street is usually the edge, but it could depend on what particular site has the actual boundaries. But the general rule we follow is the sidewalk to the street is the public space.
Okay, and so you're saying that not allowing political signs on election day when a site is a polling place is in statute?
That's in the Attorney General guidelines interpreting ARS 15511.
Are you able to send me those?
Sure.
Okay.
Yes.
Mr. Dangerfield, that's in the agency handbook, correct?
Pardon?
Is that in the agency handbook that talks about?
No, there's in the statute, it directs the Attorney General to develop guidelines for this statute about the use of political material on use of school resources for influencing the outcome of an election. And they're directed to create these guidelines. And that's what I'm referring to. And I can send all the board members a copy of these guidelines.
Okay, be great, thank you.
Mr. President, if I may.
You may.
Mr. Dangerfield, are you referring to the 2004 Attorney General's, their opinion on this?
Yeah, that is correct.
Okay, because I do have that in front of me. And part of where it starts, they give guidelines, but they specifically lay out individual school board policies may be stricter than these guidelines. And school board policies are not supplanted by these guidelines. So just throwing that out there because I know we're going to have more conversation on this here in a little bit as we progress in this policy.
Yes, that's what I'm referring to is those guidelines. So you
Mr. Dangerfield, can I ask a question really quick? Vice President Kenyon has this pulled up on his computer. Would it be okay for him to email that to the board members so we can all read it as we're doing this? Or can we send it to you and then have you send it out so when we're in the meeting we can review this and discuss it?
Mr. President, I apologize. I do not have it on my screen. I printed it out.
Oh, you printed it, sorry.
Yep.
Okay.
Can I ask a question to Mr. Dangerfield?
You may.
Okay, so in regards to Mr. Kenyon's, that the Attorney General's language says that the school board policy can be stricter, but law enforcement isn't enforcing school board policy, correct?
That is correct.
Thank you.
So maybe I could suggest something for the board to consider, and that is not using school property for elections. I don't know how many school sites you use. Are all of them being used as election polling places?
No.
No.
Which one? Which ones?
Usually the district office, but this Westar has been one in the past. Estrella has been one in the past.
When I was at Gilbert Schools, we stopped doing it at the schools because it was disruptive to the educational environment. And it was a safety concern too about people having access to the campus so easily during that polling day. The school board, the school office, the district office wouldn't have that particular infringement or that problem, but it's still school property. So my only concern is how do you enforce this? Someone's going to have to really monitor it carefully. Because all the people that are involved in elections, they're familiar with the 75-foot rule. They aren't necessarily going to be familiar with the off the school property rule.
Well, and I think we also need to consider the state statute that says it's illegal to remove political signs. So if district staff is doing that, then they're breaking the law.
It's illegal to remove political signs if they're placed legally.
Correct.
And so if they're not placed legally, then the governmental entity, the city usually quite often has a sign code group that will take care of that issue. But when it's your own property, school district property, it wouldn't be a violation of the law to remove it to the outside of the school property.
Right. I know in the city of Goodyear, they have no sign zones, and if you're in one of those, the city does remove them and disposes of them after a short time if you don't claim it. So they do also move political signs. But again, that's this ultimately, although public property, it is our property, and if the law allows it to not be on the property, then the school district removing it would be within the guidance of the law because they're not allowed on the property, is what I'm hearing you say, correct?
That is correct. That's what I'm saying.
Okay. All right, Ms. Zimmerman, any other questions on?
Page 45. This policy is about visitors. And I just, if you could help me recall, Ms. Castellanos, is there a policy about volunteers and how that is handled different than visitors? I'm putting you on the spot. I apologize.
I do not remember seeing something that was separate for volunteers. However, that's not saying it doesn't exist. I need to look through all of the policies to see.
Okay. I think that this is okay for visitors, but I think there probably needs to be a policy about volunteers, and I don't know if that's a procedure in terms of how the district, handles that. The only other thing I have here is the first line, the superintendent may establish controls and procedures. I just think the word should be shall, like he or she should do that.
Okay, so are you asking for any changes to page 45?
Just the may to shall.
Okay, and then, so this classroom visits by parents, legal guardians is fine? Mm-hmm. Okay.
Can I jump in?
Yes, please.
We do have a procedure. I mean, we could have a policy as well, but we do have a volunteer procedure where they have to come to district office. There's paperwork they have to fill out. So we don't have a policy, but we do have a procedure.
And I'm thinking there might be a volunteer policy in chapter 5, but I'm not positive.
I can't picture it. I've looked at that so many times.
There was a lot of talk about volunteers in chapter 5. I'm just not sure exactly what it was.
Yeah.
So I will look for the volunteer policy, but we do have a procedure that's set.
I'm on page 71 now. This is talking about FOIA's Freedom of Information Act, and in the middle of the page, the district shall respond to all requests within a reasonable amount of time. I think it would be great if we could define this. What is reasonable?
So I will comment on this a little bit by having worked in news organizations, filing a lot of public records requests. The courts themselves have never been able to define this, what a reasonable period is. In the handbook of open meeting, in public records request, it gives lots of caveats about what time can be. If you're short-staffed, if you're at crunch time at the end of a quarter, grading time, graduation time, those are all factors that they have deemed reasonable to take a process. Also, you have a caseload of your employees, even if you're fully staffed. So if we have to have legal review on this, which they should be to ensure that nothing is released that should not be, such as attorney-client privileged information, the redaction process. Depending on the request, it can take a long time. But I know the courts have never really been able to define what a reasonable period is. I've seen some take many, many months, and some come back rather quickly. And it doesn't seem to matter if it's a big agency or a small agency. It just seems to be the way the review process is. But I'm cautious to try to define this because I think it's an unknown, and that's exactly why the law has been written vaguely. Mr. Dangerfield, do you have any thoughts?
Yes, I do. Thank you, President Todd. You are absolutely right. It isn't defined on purpose because it's so hard to determine all the factors that are involved in it. But just a general rule, I would say a general rule is just like a 30-day period, but it can be changed significantly based on the facts involved. So the courts are the ones that would define it and would decide if you're outside that. There is an action that can be brought by someone that is waiting for their public records. Action could be brought in Superior Court, and the governmental entity can be forced to produce it and also be fined for having violated a reasonable time. But they decide whether it's reasonable or not based on the facts.
I understand. I mean, I know that what the law says as well. And so, you know, I understand that we probably can't totally define it, but if we had, you know, the district, not shall, but, you know, will attempt to fulfill it within 30 days, you know, something, but that's up to the rest of the board.
Mr. President, Mayor. I'm okay with it, how it's written. I think it makes sense.
Okay, thank you, Ms. Zimmerman. Next item.
Page 72. It's talking about public records requests on personal devices. My question is, you know, for the district and potentially legal, is there a procedure now on how this would be done? Or
Is someone waiting for me to respond to that?
Yes.
I'm not aware of anything that's out there right now. Stephanie, are you familiar with anything?
I am not as well.
No, this is another one that's really, really hard to define. And when it's personal devices, you're also talking about personal civil rights issues. So, though it can be requested, and in a legal situation, in fact, it can be court ordered that someone produce their text messages. Just for your information, I have been involved in one of these cases before that was very public a number of years ago. And it was in newspaper articles here locally. And the thing that we learned is that text messages are saved by the phone company. And you can actually get a record of the written text messages. And I reviewed months of a government elected official that had kept and claimed that they hadn't used their cell phone for any government information, and that it was all personal. And I was asked and given the task to review probably a year's worth of text messages of this individual, and he was right. He hadn't used it for any government service. But in fact, he had to divulge the information, and we were able to get it through his cell phone company.
okay. Move on to 73. It's new trust language about technology. And it's at the bottom of 73, halfway through that last paragraph, it says, anyone who misuses, abuses, or chooses not to follow the technology guidelines and procedures may be denied access to the district technology. My concern is if we put something in policy, then we need to be able to follow through. But can we truly deny students access to technology or the district's technology when they are reliant on it day to day to access curriculum and be able to do their schoolwork?
So on, well, Mr. Dangerfield, I'm sorry.
Would you tell, what are we looking at? 3-403?
It's 3-403 under appropriate use of technology on page 73. It would be the second to last line.
The second to last line. Anyone who misuses, is that what you're
Yes.
talking about? Anyone who misuses, abuses, or chooses not to follow the technology guidelines and procedures may be denied access to district's technology and may be subject to disciplinary and/or legal action. This is, and this is it with students, regarding students and staff.
I think it's both, uh-huh.
Yeah, so this is for discipline. This is to allow the district to take discipline either with an employee or with a student.
No, I understand. I see that, and I'm fine with that part. It's the part that we're denying access to district technology. And I'm just giving the example of our 6th, 7th, and 8th grade students who are one-to-one on a Chromebook, who use it every single day to access curriculum that is online. If we remove this, if we keep this policy, we need to be able to enforce it. And so how are they going to access education if they're not able to use district technology?
That's a good question, Ms. Zimmerman. And I have had a personal experience with this from in my role as an attorney dealing with student discipline, serious student discipline, and a student that had gotten involved with inappropriate use of technology was only allowed to use the district's access at the school site with some supervision. So that's how they did implement this type of a rule, is they were not allowed to use the material at home, and there was always supervision. So that's the way they did it. That district did.
And I have experience with this as well. And anything they need to do at home, the teachers would print out anything they needed to do at home for them and give them paper copies so they could still have access to what they needed.
Okay. Page 77. The line after number 3 is when students shall be permitted to use wireless communications, and it lists specific reasons. And then I just think the reason right after 3 should just be number 4. District protocol, regarding the use of wireless communication shall allow for student and parental legal guardian communication. So the first 3 are saying, here's why they can use their cell phone essentially. And I think just moving that, so that's one of the reasons to communicate with their parents.
Mr. President, Mayor,
You may.
I'm a little confused. What you're saying? You're saying they should be able to use their phones to communicate with their parents?
Yeah, it says that we will allow that. So but the numbers 1, 2, and 3 are reasons why they are allowed, reasons they should be permitted to use their devices. I just think instead of having it separate, it should just be number 4. That's all I'm saying.
Students shall be permitted to use wireless communication device district protocol regarding what? I don't understand.
Okay, so right under number 3, district protocol regarding the use of wireless communication devices shall allow for student and parent/legal guardian communication.
So my question is, when does a student need to use their cell phone to talk to their parents when they couldn't talk to the teacher and use a landline? How did all of us who grew up without cell phones talk to our parents without cell phones? We have a state law that's come into effect that is trying to restrict this. I think one of the number one complaints we hear from teachers is students on their phones. So if they need to speak, the only time I can see that they need to speak to their parents on a cell phone would be during an emergency. Aside from that, I don't see a time where they couldn't ask the teacher and do like we all did, go up to the front office, call our parents and say, Mom, I forgot my cleats for the baseball game. I forgot lunch. Forgot to tell you my homework is sitting in the washer, whatever the case might be. But I don't know why they would ever need to use their phone to call home when we have the access to use landlines to do that. And this just becomes a slippery slope as a whole that now students are always going to be calling their parents. We actually had this happen here in this district a couple of years ago, where one particular parent at the Liberty District was just showing up at the front office. I'm here to pick up my student. And what are you talking about? Oh, she called me and said, come pick her up. She didn't feel well. And she was using it from her Apple Watch. And the parent even argued that your policy says you can't use cell phones, but it says nothing about a watch. We quickly changed that policy wording there. But again, we shouldn't just have students deciding they don't feel well or want to go home or whatever and just randomly picking up a phone to call that when they can do it the way most of us, at least those of us with gray hair, did it. And go to the front office, make a phone call. I don't think that's a problem. If somebody's sick, if somebody forgot their homework, forgot their cleats. When my daughter was at school here for many years, till she was old enough, she didn't have a cell phone. And if she forgot something, she called right from the teacher's desk phone with the teacher there to make sure that the phone call was appropriate and was taken care of. The other thing that I think this helps a lot is if we have any custodial situations or that nature, students don't always understand, and they may be getting text messages from a parent that the courts have deemed shouldn't be taking place. It's hard for a school district to always monitor that if they're just on their cell phone. So I would actually just like to see it stricken and say that if they need to contact anybody via phone, unless it's during a true emergency, a school declared emergency, I might tighten that up, because if you just forgot your medicine, just tell your parent you forgot or tell your teacher you forgot your medicine. You can call home and get it from a landline. And we just strike that from the record, and messages can come to the front office just like they did for hundreds of years.
Mr. President, if I may.
You may.
I agree 100%. This is something that's been brought up to me time and time again. And I think that it really needs to be reeled in, along with what you're stating. I would also state just during an emergency, because this is one of the things that we've been dealing with, and it's becoming more and more prevalent in our generation in this time period, where there's so much electronic communication, and it's a distraction for the kids. We're hearing that from the teachers, that they can't teach because the kids are distracted by the devices, and limiting that, going back to exactly what you said, not to reiterate everything, but I mean, I have a daughter who's currently enrolled in our district, and she doesn't have a cell phone, and whenever she needs to, she goes either to the front office or her teacher's desk with the permission of staff and calls her dad and lets me know what's going on, what she forgot, what's going on. So that, I would be in agreement with this. I think in our ASBA policy, it said something about they're not permitted in the classroom unless approved by the teacher or something. But even that, I really just would like to keep this wireless communication devices only used during emergencies.
We will need to check on the legality of that, because this was in direct response to House Bill 2484 that was just passed.
Okay.
So I just need to check the legality of it. I'm sure it's fine, but I want to make sure that we'll check with legal.
Can I add something?
Yes.
You know, first, I think that we need to keep, if they need the wireless device for their own medical condition, for kids that have type 1 and they're, checking their blood sugar, oftentimes it's, I believe, can be on their cell phone or something like that. But I also think that kids are going to have cell phones. I don't think that we can get around that. And so causing them to go up to the front office all the time. I think a simple text to your kid, like, hey, pick up your little brother, like, I'm not going to make it home. I don't to have to call the school, then the school has to call the class to interrupt the teacher. I think we already have in the student code of conduct or handbook that, the cell phones need to be kept off and in their backpacks and things like that. But I think saying that parents and their child can't communicate, I'm not comfortable doing that.
I don't think we're saying they can't communicate. I think they're saying they need to communicate through the office. The trick is you might know at noon that you're not going to be there to pick up your child and somebody needs to pick up their little brother and walk them home. If they get that message at noon or they get that message 10 minutes before school's out, that's less disruption if it goes to the main campus, to the main phone at the district office, who can then send an email or a message to the classroom at the end of the day, versus having half the class getting text message from their parents all day, because then it's going to lead to another question. Well, Mom, I wanted to go to my friend's house. Why do I have to pick up little Johnny instead? And now we have a back and forth. It's much easier, just as we all did for many, many years. It goes right through the front office. And I'm going to stand pretty firm on that idea. We're not stopping any important communication to the student. We definitely are not stopping anything if a child is diabetic or something and has a medical, they have devices for diabetes that report to the phone. We're not stopping any of that. We're stopping all the disruptions that happen. You just imagine 26, 27, 28 kids in a classroom and the phone's going off all day. Mom and dad both think there's an emergency. They both send messages. Neither one may be an emergency. If it goes to the front office, they can field that call and at an appropriate time, let the teacher know. Maybe it's just an email, but that email comes into the teacher every day before class is out. Teacher can make sure they've cleared their inbox. They have all those messages. They've passed those on to the students. If it's urgent, then certainly somebody from the front staff can deem that emergent. They can walk down to the classroom and deliver a message to the student right away. I'm guessing if it's that emergent, they're probably going to be checking them out of school anyway, but it's not an isolated event of just one student once in a while. It's somewhere between 25 and 30 students that could all be getting text messages throughout the day. And it just is always a response back. I know anytime I would text my teenage daughter, there was two options. You either got a whole bunch of questions back or it was radio silence, depending on the mood of the day. But I love her to death, but she will agree if she's watching this that that's kind of how that is. To this day, you'll message some people. Some answer right back, some don't. But how do we even know if it's something critical that the student got their message if it's a text? If it's to pick up your little brother and walk them home, and let's face it, students are forgetful, and that phone is at home, now the message is delivered, don't know if they got it. But if it's a direct, verbal, human-to-human contact, message, conversation, then you know that that message has been delivered, and we don't leave a smaller sibling behind because we thought the text message was delivered, and it wasn't.
So I did find in our parent-student handbook, it does say the cell phone must remain in the student's backpack and switched off at all times during the school day, including lunch, recess, special classes, and while being transported by bus. That's what it says in our handbook.
So that further solidifies if you send your student a message during the day, they're not going to get it until the school's out and they're on their way home. So then they've left in this example, they've left their little brother or sister behind because they didn't get the text message because the phone was off and in their bag.
That's what it's supposed to be. That's what it says in our handbook, but it,
Okay.
that's what it says in our handbook.
We all know what teenagers are actually like and what happens in the classroom.
Which is exactly why I think we need to have this policy, because it will eliminate that and we can take action to not disrupt the rest of the classroom, because we know the older kids probably are not following it. In this case, before with the watch, it was a first or second grader that was on their phone constantly. And there was a time where the teacher reached out and said, Mom's been to school 4 times today because 4 separate messages have been sent home saying that the student forgot something or needed something. That's a lot of disruption.
Mr. President, if I may.
You may.
This also, the whole phone issue comes into play with our children's education. I mean, I think what you're getting at is, Mr. President, is the disruption in the class, where now not just one kid who's answering a text isn't paying attention, but it's a distraction to the class when it's multiple. We're seeing, Arizona is one of those states that, we're not very proud that our proficiency scores, our test scores aren't the best in the nation. We're some of the lowest in the nation. We want to get that up. And we're being told by staff, by teachers, that this is a big problem of communication devices in the classroom. It's a distraction. And so to help our children, I think we need to basically say they cannot use this. And I know, like Dr. Moharn, you said, it's in the handbook. They shouldn't be using it. Even on the buses, it says, but we know they are. So, having it in the policy, and then as Board Member Zimmerman said, we need to be able to follow through and hold these kids and families to these policies. And so I think it's critical for the learning environment that we're giving these kids. Because, you think about the kids that don't have these electronic devices. It's a distraction for them when their friends are all getting messages, when the teacher's distracted because of everything that's going on. And, maybe Johnny has a nice, cool, brand new iPhone and, not supposed to be showing it off, but it's a distraction. It's all a distraction. It takes away from the learning environment. And so that's what I want to focus on is helping these kids become more proficient, learn better, be better at, and I want to say something about AI. I know we're not quite there yet. It's the next paragraphs. But I'll reserve that till we get there. But it's one of those things. We're just helping our kids succeed rather than just allowing the distractions to continue. And we know that this plays over into discipline. This plays over into respect for the teachers and to the other kids that are in the classroom. And the problem isn't a one-time issue. It's that this has been abused for so long. Not just in our district, obviously. It's mostly abused in the high schools for sure. I get 2 high schoolers myself and dealing with that. But in elementary, in middle school, this is something we shouldn't allow to be a distraction in our classrooms. So that's where I'm at.
Mr. President, may I? Hey, just real quick, I don't want to keep beating this dead horse, but I don't think we should ever make a policy one way or another just because we think the kids are going to do it anyway. I think that's a bad thing for us to habit to get us into. Yeah, they might use their phone, but we know they're teenagers, but I don't think we should make our policy around knowing a kid's going to break a rule or not. We still should make it and enforce it how we think they should be doing, not what they're going to be doing.
Okay, Ms. Zimmerman, your next note.
It's on page 78. It's talking about AI. Number 4. These are instances in which the teachers have the discretion to authorize students to use AI tools, basically. So number 4 says writing assistance. AI /NLP tools can provide grammar and spelling corrections as well as suggest alternative word choices and sentence structure to help students improve their writing. I think when you allow them to help with sentence structure, you're going into a very fine line of plagiarism. And so I'd like to see us remove sentence structure. And I know what they're saying to help students improve their writing skills, but to me, if you don't read that correctly, it's in my mind suggesting that AI is helping them improve their writing, and I feel like the teacher should be doing that and not AI. So I'm almost, at the very least, I'd like to see us cross out sentence structure and improve their writing skills. But I'd also be okay removing number 4 as well.
Mr. President,
You may.
I know that AI is a slippery slope. I get that. I'm okay with this only because it says the teachers have the discretion to authorize. So the student can't just go do it. It still puts it back on the teacher to let the students know what program they can and how far they can use that program to affect what they're doing.
Vice President, can you have any thoughts?
Yeah, thank you. First of all, I'm glad that the whole majority of this whole AI section is basically saying the students can't use AI for work. We're talking about the exceptions. And so I wanted to point out to the community, because this is something that's been brought up to me, about how computers are doing the thinking for our kids, and our kids aren't learning. They're not gaining the skills that they need. Pretty much going to Ms. Zimmerman's point is, these kids, they need to learn these skills without the assistance. I understand AI is a great thing as a secondary thing to help you with, right? And for adults, it's a game changer in a lot of things. But for kids that are in the elementary schools who are developing, they're learning their skills, I don't think AI really should be allowed hardly at all. But for very specific few exceptions, which are laid out here, the 5 exceptions. And so in regards to this, I am okay with it just because, as Board Member Cirincione said, the teachers have the discretion to authorize the students to use the following. Now, I want to make it very clear, if the teacher doesn't authorize it, it is not allowed. And this should be very unique situations where it is okay. Because again, I think we're stilling those possible skills these kids could be learning by just substituting with AI, with the computer program. So as I read through this, I think these 5 are okay as they are.
Members, I might also provide an alternate idea. I understand both sides, and I certainly do agree with Ms. Zimmerman that let's face it, our people today are having a hard time writing. We once upon a time had cursive in the classroom. That went away for years. Now we've gone to technology. Printing is starting to go away. I look at the way some children write, and that reminds me of how kindergartners used to write. So I'm concerned that we're losing some skills, and I definitely understand what Ms. Zimmerman is saying. I think maybe we word this a little differently and maybe even restrict this to the lower grades where they need to form sentence structure. So maybe we only allow AI to assist with sentence structure in 7th and 8th grade. And until then, you kind of need to understand the sentence, how to structure a sentence before you rely on AI to do it for you. Because I feel like these days students are very smart and they take the path of least resistance. So I'll slam down a really poor sentence, not really care about it, and then I'm going to use this policy of AI to say, clean this up for me. So I understand what both of you are saying, what both sides are kind of saying here. I'm wondering if we can limit that to 7th and 8th grade or something upper level where they first have a clear understanding of sentence structure. And then perhaps we build some instruction because, again, AI is the way of the future. Students need to understand it, but I would like to see them understand, first of all, how to structure a sentence on their own, and then down the road start learning how AI can help them refine it. And I think maybe if we limit it, I don't know, Ms. Zimmerman, if you think that would be somewhat of a compromise or help out, or if I'm being clear on what I'm trying to explain with this.
I do understand, but I'm not sure that younger grades are going to be using AI. And personally, I think the junior high kids are the ones that I worry about. But again, it's the will of the board.
Can I offer some considerations here?
You may.
The Department of Education for the state of Arizona is currently using AI as tutoring programs for students who are deficient in reading and in sentence structure, writing, ELA skills. So they offer these free programs to students across the state. So I'm not sure if actually removing this writing assistance would remove the ability of our students to be able to be tutored by these AI programs and the NLP models.
Mr. President,
You may.
the term AI is like very broad also. So if I'm not mistaken, when you're using Microsoft Word, for instance, and you're writing it and it tells you use different punctuation, technically that's AI. So if we go out and say no AI, then we're really limiting what they're doing. For sentence structure, if it says, if you get that blue line under Microsoft Word, I'm pretty sure that's AI telling you to move that somewhere else. So I'm just saying we just got to be careful, because if we just say no AI for sentence structure, now we got to make sure like they format their word usage to make sure they're not using automatic spell check, all kinds of stuff like that.
All right, members, what if we just consider AI is so fresh still, and we're learning. I mean, everybody's learning it. It's changing leaps and bounds. Every time you check in Chat GPT, it does something more. Maybe we need to accept this as it is now, and then study AI a little bit more and come back. We can approve this perhaps, and then come back with a tighter AI policy that I can see AI becoming a policy of its own sooner than later. I know the other thing that's happening with AI now, they talked about this at a school board conference a year or two ago, is now bumpers, because AI is actually creating its own facts that aren't facts, and it's referencing things that are now false. So that's the next wave of AI already, is AI will create its own, I don't know what you call them, false facts. I don't know what that would be, but it's sourcing itself. So I think we're gonna have to learn as a whole, and maybe even engage our IT department to make some suggestions on this. But I think everybody has good points and is probably all on the same page, really. It's just a matter of how we word it appropriately.
Well, as a reminder, the trust will update again in August or September of every year. So they will send updated policies. So that may be a time to review this policy as well and give you a couple of months.
Sure. Okay. Ms. Zimmerman, what's your next?
On page 80, this, I think it was removed because of, the new language from the trust, but this D section is what I'm concerned about removing. I think it's one of those things, a responsibility of the superintendent. I had mentioned before in chapter 1 about it didn't define all of those responsibilities, but I found them more as I went through different policies, and I think this is one. And just the protection of our data and security, I feel like we need this in policy. So I'm just referring to section D on page 80.
Ms. Castellanos, do you know why did the trust remove it?
Yeah, so the entire policy was removed and replaced with the policy above. So this is... So that whole section was removed and replaced with the policy that was above.
But it doesn't cover any of this now.
Mr. President, if I may.
You may.
So I think it's it's page 75 starts this terms and conditions. And then as you go down, there's the bullet points. And I think those are the new language that replaces the previous stuff. Accessing or downloading VPNs or other proxy avoiding extensions, this is, I believe, what the trust has replaced it with. Is that accurate?
Yes. It starts as 3-403.A.
This is more about students, though. The new policy, page 70, or I assume it's mainly page 76, right, Mr. Kenyon? Okay, with the bullet points. And this is about students, but this is about like the protection of our data and how we protect our data as a district. So I don't think they're similar enough, in my opinion.
I do have to agree with you. And I don't mean that in any bad way. I see what you're saying, and I do think it's important that we're providing, this to me looks like it's more providing staff with training on protecting data, more so than the students. I'm not sure if it would be the superintendent, or I guess we could say the director of IT shall implement, maintain data management. They're probably going to be more versed in that than the superintendent. But I can see that, here.
So are we agreeing to add in section D to 3-403?
I
If I could
personally
hit the moment, please, President Todd.
you may.
And that's a very important section that Ms. Zimmerman is pointing out, and I think it's got to be replaced in one of the other chapters. I think the trust must have moved that to another spot because it is important information that should be in policy. Do you know, Amy, if it hasn't gone some other place in the manual? I think maybe we need to do some research on that because that is important language.
Yeah, we'll need to do some more research on that because, like I said, the updates were just added in on Monday. So we'll need to do some more research and I can bring it back to you.
Okay. Ms. Zimmerman, you're next.
Page 88, number 4. It's talking about pro or con statements for a bond. And it says the governing board may not submit a pro statement, and the governing board has always submitted a pro statement. So is this new statute?
Mr. Dangerfield?
Oh, sorry.
I'm not familiar with the new statute on that. This is the governing board makes a statement in the handbook, in the pamphlet, the voter pamphlet for a bond that is already a pro statement. So what they're saying is that the governing board doesn't do a different one. It's that there is a statement that the governing board has to a resolution or develop a statement promoting what they're asking the voters to approve. That's separate from a pro statement that goes in. There's a 500-word limit, I believe it is, that the community is asked to either do a pro or con. I think they allow up to 10 statements to be submitted, something like that. But that's different than the governing board statement to the public, to the voting public, that is authorized and approved actually do it in a governing board meeting.
Okay, the bond usually, from my memory, is unlimited pro and con, and it's the override that only allows 10 each way. Is it a statute that the governing board may not submit a pro statement?
I do not know the answer to that right now. I'll have to look at it.
Okay. I do think we are essentially submitting a pro statement, and so I would suggest that we just remove that sentence because I think it is confusing to the public because I haven't been involved in it since 2019, the actual bond part of it, but that would be my comment.
Mr. Dangerfield, is this basically saying that we can't submit two? The district is going to submit a pro statement, but
No,
then the board can't come back and submit a second one?
The district can't. The district cannot submit a pro
I didn't
statement.
think so either. Yeah, I'm a little confused by this language.
Sorry, I didn't mean to interrupt.
I do agree. We're going to have to look at this.
Okay.
Okay, on page 91, number 2, I just want to remove the word governing board members from the statement because in the situations in which we're not allowed, or anybody, the district acting on behalf of the district, are not allowed to, display apparel or influence the outcome of an election in a classroom, an instructional setting, or at a school-sponsored extracurricular event where they are supervising or assisting with supervision. The governing board is not doing any of those things. So I just don't think it should be listed because we are not participating. We are not in a classroom, in an instructional setting, and we're not supervising a school-sponsored event.
Mr. President, may I?
You may.
But we would be in a classroom. We could be possibly in a classroom, like if we go on tours.
If I could interrupt for just a moment, please,
You may.
Mr. Mr. Todd, that is language right out of the Attorney General's guidelines again. I'm looking at it. It's on page 11 of the Attorney Guidelines. It says board members, personnel, and others acting on behalf of the school district shall not wear political buttons, T-shirts, hats, or other items displayed on their persons or apparel that are designed to influence the outcome of an election in a classroom, in another instructional setting, or at a school-sponsored extracurricular event
Okay.
at which they supervising or assisting with supervision or organization of extracurricular event. I think the question, the reason the governing board is in there is when you're there as in your official capacity as the governing board. Like, for example, a governing board meeting. When you are there as the governing board member, you're restricted from doing that political activity.
Okay. And again, I would just ask that you send us all, you know, that, so
see
we
you
just,
tomorrow
I can reference it for other things.
I'm going to send it. I'm going to send it to Minnie and let her distribute to the board. Okay.
Okay.
Mr. President, if I may.
You may.
Mr. Dangerfield, I have emailed you, Ms. Camerata, and President Todd the link to that. You guys are more than welcome to share that if you want. I didn't want to email it to everybody just because I wanted to be careful with open meeting law.
Right.
With that being said, it looks like most of this trust policy derives directly from that opinion. And so even the following up further down questions that the board would have, I would reference the board to this opinion by the AG.
Mr. Dangerfield, is there any reason that Ms. Camerata can't just put this into a Google Drive? It's good reference at any point for the board. Would that be acceptable for her to do?
Absolutely.
Okay. Can you do that? Thank you. All right. Your next one, Ms. Zimmerman.
Okay. So a 92 and 93, you know, I know that we're all going to have a discussion about this, which is fine. You know, and I think, you know, the situation that we got into is that we, you know, my concern here is that it put the district in a difficult position. I said this back in, I think, December, is that if the way that it's written, allowing signatures to be collected on school property at an extracurricular event seemed concerning, and it wasn't the way our original policy was written. So I think we just need to be clear in the expectation, because now there's been two different legal opinions that have been given to different people. And so I think we just need the clarity of which legal opinion.
If I could just insert, this is still that same language, right, from the guidelines from the Attorney General's office.
Mr. President, if I may.
You may.
I would agree with Board Member Zimmerman in regards to this becoming an issue where it does put some liability, I would say, on the district, some hardship in trying to figure out certain things. There's a number of things in this opinion that make me want to refer back to the beginning of it where I started, where it states individual school board policies may be stricter than these guidelines. School board policies are not supplanted by these guidelines. This is one of those areas where I know we have to make sure legally we're okay doing it, but I'm okay saying no. I think Ms. Zimmerman's talking about number 6 right there, petition circulation.
Yes.
I really don't think it should be done on school grounds at all, district property at all. I know in the AG's opinion, it does say, right there, we have it up on the screen, number 6, I'm going to go right to the bullet points, just above the bullet points. This does not prohibit individual employees from voluntarily exercising their rights to circulate petitions in their personal capacities on non-duty time. So that's outside the classroom, outside any instructional setting, or at a school-sponsored extracurricular event, as long as they are not supervising or assisting with supervision or organization of the extracurricular event. So that in itself is basically kind of giving permission. The problem I have is if we go back, and this is going to be sorry, I'm going to find it real quick. On page 7 of this, we're looking at the terminology.
Can we pull this up so that we can see it, what you're looking
Oh,
at?
I'm sorry.
No, it's okay. It's okay. Or can you email it to us real fast? I
I
apologize.
sent it, Minnie was going to make it
Manny,
available.
Can you put that in a shared drive really quick for all the board members to see the document? Actually, Mr. Dangerfield, can I just email it to everybody really quick? Will that be okay?
Yes, that's fine.
Okay. Okay, yeah, go ahead. You got it. You can just send it to every board member.
I'll kind of wait till we're ready.
Mr. Dangerfield, I know we spoke about this previously as well, and you had recommended that Ms. Siegel is the expert on this, and she gave us very clear advice and actually was part of writing the AG's opinion on this. So I think it would be wise for us to follow her lead on this. Not questioning you, but she did have a very
No.
active role in this, and I believe your recommendation was to follow her advice on it as well.
Has great experience in this area. She was on the committee that drafted these guidelines.
Right.
So are you suggesting to remove the third bullet?
I am suggesting, well, I guess let me continue with my conversation or what I was talking about. I don't know if we're ready to, if you guys have received that email yet. I'll make sure that everybody follows along or else we'll all get off on sidetrack.
Vice President Kenyon, can you just tell us the page that you're on to?
Yeah, page 7
Okay.
on, it's going to be on the AG's opinion though. It's not in the trust policy.
Yeah, it's the document that's being emailed.
Okay.
What I might suggest we do is just yield to Ms. Siegel on this and ask her to provide you some language that's within, she is truly the expert on this section of the law. Having been on the committee that wrote it, she understands the dialogue that took place amongst the committee. So maybe we just follow up with her and get definition on that, because ultimately I think we need to follow her advice.
And I would be okay with that. I just want to make a point though, with this on page 7, if we've gotten that, at the bottom of the page under terminology uses or used. So the terminology for person acting on behalf of or aids a person acting on behalf of. And it says a school district or charter school may means that the person is acting with the express or implied consent or assent of the school district or charter school, or is an aiding in such person. The problem, the gray area, I guess, is the implied consent. So when you have staff, let's say at a baseball game, walking around with a petition and she says, I'm a teacher, or somebody runs up to her and says, you know, hey, you know, miss whatever, or teacher, that, you know, could be implied consent. I mean, when you're looking at they're acting on behalf of the district, because we know staff carry some weight behind what they are trying to get across. And so in my eyes, that can be a very gray area. And so to be safe, I do think it's best if we can limit or restrict any kind of anything that has to do with elections on district property, any way it goes. And so it's one of those things where I agree with Board Member Zimmerman. It can get us in a lot of messes if it's not very cut and dry and spelled out. And that's my concern.
And honestly, when I first read this back in December, I was very surprised to see it in here like this because it's not what we currently have. So I just want us to be consistent.
So I will defer to Ms. Siegel and then bring you all back additional language.
Thank you. All right, Ms. Zimmerman, next, I think, page 93?
It's all related, so
okay.
I'm good. Thank you.
All right. All right, members, anybody else have anything really quick through there?
I do real quick, and this is going back to that page 93, where we talk about private vehicles. One thing I would like to add that wasn't in the trust policy, but it is actually in the opinion. Oops, what did I do with it? I got it somewhere, but I have it written down here. I would like to add, so when it's talking about vehicles, and it talks about, people allowing, putting signs and bumper stickers and things on their vehicles, how that is permitted on somebody's vehicle, even if they're staff, as long as they're coming to a district event or they work there, they park there. But there was a section that talks about, let's see here, the school may not permit the school parking lot to be used as a permanent parking for a vehicle displaying a candidate's campaign sign in the lot when the owner of the vehicle is not visiting the school for school business or other permitted activities at the school. I think that's really important that we have that language in there because
Where are you finding that language? I'm sorry.
I will have to find exactly where that was because
That's in the Attorney General's. No, I see where it is here, where it can be inserted, but is that in the Attorney General's report?
Yes, it is actually on page 10, number 3.
10. Number 3.
And so I took that language directly out of that. So,
Okay.
yeah, if we can add that, because I can see where that can be abused. Somebody could just park their car there for a week and just have political signs on their car. So,
Thank you. Any other questions or considerations for Chapter 3?
Speak now or forever hold your peace, they say. No, forever is appropriate, but at least for the moment. All right.
Okay. I think
that
that'll
covers it. Thank you.
end our Chapter 3 discussion. I will go ahead and get these revisions done and then sent back to you for approval at a later date.
Thank you. All right, members, we'll move on to item 3.1, board comments on agenda topics and items for future consideration.
Excuse me, President Todd.
Yes, ma'am.
It is an action item.
Yeah, but I think we're not taking action because we got to come back for a third read.
Okay, so would you like for the motion to be coming back for a third read or no?
I think it'll just come back because we're not taking anything at this time.
Okay.
We're not really tabling it. We're just not taking action, which is,
Okay, I'll note that in
Right
the
on board.
meeting minutes.
yeah,
Thank you.
okay. Mr. Dangerfield, do you agree with that?
Yes.
Okay. All right, now we'll move, thank you, Ms. Camerata, though, for keeping us honest. Item 3.1, board comments on agenda topics and items for future consideration. Ms. Zimmerman,
I don't have any at this time.
Vice President Kenyon,
none at this time.
Board Member Cirincione.
None.
Okay. I just have two I'd like to bring forward. I'd like to, for us, along the lines in the Attorney General's, or in the policies that we spoke about here on vehicles. I do think we have some people who are parking their commercial vehicles in our lots on the weekends. And speaking with legal, it's very important that we devise a no trespassing policy with some signs and also restrict the parking of vehicles when the school district is closed or when the school campuses are closed. So I'd like to ask staff to put something together and bring that forward to us in a future meeting. All right, item 4.1 is upcoming board meetings. Members, we actually have an update as of today. We're going to have a meeting, an executive session on Monday, May 12th, correct? Ms. Camerata? Yeah, Monday, May 12th, that's going to be at 11 o'clock. It is strictly an executive session. We will do to do that, we'll open up a general meeting. We'll go directly into executive session. We'll come out of executive session, and there may or may not be one action item after that. And that's going to be at 11 o'clock with council. Yeah, that'll be the action item there. Then we'll have the Tuesday, May 13th. There's a retiree reception and a regular board meeting. Tuesday, May 19th will be a work study. We have two on here for Saturday, May 24th and June 7th as work studies. That's been set aside for policy. If we need to get into it, we have those. That was the plan for those, right, Dr. Mahorn? So
I was
the
writing
May
it down.
24th and June 7th are work study sessions if we need them for policy revision and adoption, correct? Okay. But we look like we're moving through here, so maybe we'll get done. And then Tuesday, June 10th is a regular governing board meeting.
Mr. Todd, can I ask a question?
You may.
Okay, so are we, just so for planning purposes, are we all committing to these Saturdays just so that we can plan for
Well,
policy?
I think that's the plan, is those are the open dates that Ms. Castellanos has and the dates that are available. So we need to plan for those if we have them, correct? Yeah.
Okay, and we're not adding, just because in the email we got, there were some other weeks. I think we can accomplish them in these three, but I'm just wondering, is the plan to accomplish them in these three? Or do you think that we will be adding more?
I hope we can get them done in these three. I think if we spend enough time on those Saturdays, after spending one, we may be even more encouraged to get through this. And obviously we want a thorough review, but I don't foresee that we'll need any more time than this. I'd like to have these adopted so there's plenty of time for staff to read them, become familiar with them before they technically go, well, it won't be a technical, it'll be real. They'll go live on July 1st. And I'd like to give everybody as much time as possible to review them, understand them, and pose any questions if there's any conflicts with what they're currently doing. I can see that we will have some probably come back for a review a little bit, but if we can get it done and have them adopted by June 10th at the very latest, ideal if we could do it sooner, then that gives staff some adequate time to review all the policies.
Okay, thank you.
Mr. President,
You may.
what time are we talking about on Saturdays? Because I'm gonna be honest, I'm opposed to doing these on Saturdays.
Well, we can break these Saturdays up into about 8 weekdays if you would like to, because instead of a 2-hour session, we're going to have to, instead of a long day, we're going to have to break them up. So if you have other days you'd like to propose, we can do that. But unfortunately, when you're doing this kind of work, it's pretty difficult. And we're also working with Ms. Castellanos' schedule. Correct me if I'm wrong, but we've actually taken considerably longer than what was originally planned to get these adopted and done. So her time is limited, and this is basically the time she has available.
Mr. President, for me?
You may.
Yeah, I think what we did before, Ms. Castellanos, if that works for you, with the policy revisions that come out, if we're able to look at those and see, the trust, because we still have 3. We've approved 1 and 2 tonight. We have 3, 4, and 5 to go through the reads. And if we're able to get those, we can review those on our own time, email you with questions, or that way, when we come to hopefully Monday, May 19th, we have a good idea, and we can just quick hit these. We might not need the Saturdays, but I think it's good for us to just set those aside just in case. I'm hoping that May 19th and possibly May 24th will be the 2 that we have to have. And then with that June 7th being the day that if we can get it all done before then, we won't need that, so.
Yeah, with all hopes, we would have May 19th, we would be approving Chapter 3. We'll dive into Chapter 4. Chapter 5, we're going to need a Saturday to get through it, and that's just the honesty of it. But my intent is I will have all legal opinions and questions answered from Chapter 4 within the document that you have or that you get. So you will not be waiting for legal opinions. You won't be waiting for like questions that you had previously to be answered at all. Instead, you'll have all of those right into the document itself, and we shouldn't need to go over those questions again. Hopefully your questions would have been answered sufficiently in that manner. And you'll have everything up front. But the chapter 5 is a hefty chapter, and we are going to need some pretty consolidated time to go through it. So, and to have those discussions. So we'll need at least one Saturday. That's just, or we'll need a 4-hour block somewhere else.
Okay, members, it doesn't sound like we have any more to talk about on 4.1, so we'll move to 5.1, the adjournment of the special meeting. We'll show it adjourned at 6:55.